So after John Marshall writes in Marbury versus Madison that the federal Supreme Court, not the state Supreme Courts and not the state legislatures, will decide what the Constitution means, the government establishes a bank, and it puts one of the branches of the bank in Baltimore, Maryland. And the legislature of Maryland decides it's going to tax the bank. Now, this is almost inconceivable today that a state would tax a federal entity. I would love to be able to tax the Federal Reserve out of existence. But so the manager of the bank, of course, refuses to pay the tax, and the case makes its way to the Supreme Court. And the issue is, does the federal government have the power to establish a bank? Not does the state of Maryland have the power to tax any bank in the state? It does. But does the federal government have the power to establish a bank? And the government argued that it could do so under a clause in the Constitution which lists the 16 specific discrete powers, one of which is to regulate goods between merchants as they pass over interstate lines, called the Commerce Clause. And then there's the catch-all phrase, sometimes called the Elastic Clause. And it basically says to do all which is necessary and proper to carry the foregoing powers into execution. So this case, McCulloch versus Maryland, McCulloch is the manager of the bank, Maryland's the state that's trying to tax it, construes the meaning of the necessary and proper clause. Unfortunately, it is being construed at the same hands of John Marshall, who said that the federal government will determine its own powers. And so John Marshall wrote in an opinion unanimously agreed to that necessary and proper doesn't really mean necessary and proper. It really means needful and helpful. And if they meant necessary, they would have said absolutely necessary. But because there's no modifier on necessary and proper, he dialed it back to needful and helpful. These two cases alone, neither of which has ever been seriously challenged in the modern era, and both of which are so ingrained in American constitutional history that those of us who study this and practice it and write about it and talk about it take them for granted, have set the federal government on the pace for the massive expansion that we know today. So the states don't decide what power they gave away. The federal government decides what power they took from the states. And necessary and proper, because it means needful or helpful, has created an entire area of federal jurisdiction never contemplated by the framers. How do we know it was never contemplated by the framers? Little Jimmy. Little Jimmy gave a very famous speech on the floor of the House of Representatives, now known as Madison's Bank Speech, in which he argues, hey, I wrote the thing. Those are my notes. Necessary and proper means necessary and proper, and the federal government does not need a bank in order for it to operate. It can put its money into banks that are chartered by the states. We did that intentionally so as to put a further check on the power of the federal government. It is a great speech if you ever want to read it. It is a masterful analysis of the concept of limited government. It's also an analysis of the Ninth Amendment,